Thank you, Mr. Chairman. Mr. Chairman, we talked earlier about the people who testified and gun owners in this state. We see them every day. We pass them on the street. We talk to them at our local coffee shops. We sit with them in meetings. We cheer with them on the sidelines of our kids' football teams. And they are our neighbors, armed. They're not gun nuts. They're not crazies. They're not characters out of the movie Deliverance. They're our neighbors. They live next door to us. They live down the street. They're doctors. They're lawyers. They're engineers. They're truck drivers and plumbers. They're people we know from the PTA. We serve with them on the Lions Club. They're veterans. They teach our children in school. They're soccer moms. They're rape victims. They're entrepreneurs. They work at Pratt. They work at Sikorsky. They work at EB. They work for the state of Connecticut. They're the NRA. They're the CCDL. They're good people. And they shouldn't be demonized. They shouldn't be blamed for every time some crazy idiot criminal kills somebody. They protect people. Millions of people every day across America carry firearms. And they do it safely. They do it responsibly. And they rely on us to protect their rights to do that. They protect themselves, their families, and like the Constitution of the state of Connecticut says, they have the right to protect themselves and the state. They have the right to bear arms to protect themselves and the state. They're not some lunatic knuckle-dragging yahoos. They're not racist, right-wing militiamen. They're our neighbors. They're the very people that we need in this country and in this state. They're Christians, Muslims, Jews, Sikhs, every other religion. And increasingly, they're women and they're African American. And many of them know firsthand about violence and rape and abuse. They either see it on TV every day or they see it on their own streets or in their own homes. They're refusing to be victimized. And far too many of them, that's already happened, and they're going to refuse to be victimized again. Most of the time we don't even know they're armed. Sometimes we do, but most of the time we don't. They're like hundreds and thousands of people every day that you pass on the street that are armed. It's like makeup. A lot of women, they put their firearm on when they get up in the morning and they get dressed. They go drop off their kids at daycare. They wear it all day and they drop it off. They take it off when they get dressed, when they go to bed at night. As a group, they are the most law-abiding citizens in this country. Check FBI statistics, Department of Justice statistics, Centers for Disease Control statistics. Legal gun owners commit far less crime than the average in the population. They prevent thousands of crimes each year. Rapes, assaults, burglaries, robberies, murders, mass shootings. They use firearms for protection. And it is up to us to make sure that our laws protect them and are understandable by them. Like, most people don't understand how a car actually works. They get in, they drive it. They know how the pedal works, they know how the steering wheel works, but they don't know the inner workings of it. They don't know how the power goes from the gas pedal to the wheels. Similarly with guns. Most people don't know how the motion of their finger turns into a bullet flying down range. They don't understand the mechanisms of it. Even if they're desperately trying to do the right thing, they want to make sure that whatever firearm they have is legal. They don't want to be in violation of our statutes. They're trying to do the right thing. They rely on us to draft laws that they can understand. This ghost gun bill is completely and utterly incomprehensible. Now, most people may read it and not think that, but those people don't know anything about firearms. This bill tries to ban so-called ghost guns in two different ways. One is, it says that you can't possess a hunk of metal or a hunk of plastic, essentially a paperweight, that can be turned into a firearm. You can't take this piece of metal that may or may not look like a firearm and turn it into a firearm. The other way, the second way this bill tries to do that, is it says you are not allowed to make a firearm without a serial number. Okay, two different ways. One is you can't take the action. The other one is you can't possess the piece of metal. Now, the first one, the possessing the hunk of metal, turning the gun into turning the piece of metal into a firearm, I don't agree with that, and I think that, but at least people understand that. At least people will understand you're not allowed to take something and turn it into a gun without a serial number. Everybody can understand that. You can't take a hunk of metal, you can't take an 80% receiver, you can't take a 79% receiver, you can't take a 4% receiver, you can't take a block of metal, you can't take a pipe, you can't take a hunk of wood, you can't take anything and turn it into a functioning firearm unless you get a serial number. Okay? Simple enough. Everybody understands that. But with the other way, virtually any block of metal, virtually any block of plastic, virtually any pipe, piece of wood, pens, there are innumerable things that can be turned into a firearm. If you have the skill, and maybe you have the machinery, you can turn virtually anything into a firearm. Now, during the public hearing we were asked to pull up a website called ghostguns.com, and we all looked at it, and it showed a device that is not a firearm, but it looks like one, and it comes with all the parts. It comes with a barrel, it comes with a slide, it comes with springs, it comes with all this stuff, and it comes with a receiver that is not a firearm, that you have to machine into one. And we were told that the goal is to ban the stuff that this website sells. All right, well, the problem is that what this website sells, it's selling as a combination of a bunch of parts, all of which are legal, and we are trying to make one of those parts illegal, and the one of those parts that we're trying to make illegal is the one part on the whole kit that isn't even a firearm part. It is a paperweight. The federal government classifies it as a non-gun. It isn't a functioning piece of a firearm. All the other pieces may be, but they are not guns. They are not something that you can turn into a gun without a functioning lower receiver in many cases, or upper receiver. So what we're trying to do is we're trying to ban sort of an idea that's on the internet. And by banning this idea, what we're doing is we're saying that you can get all these parts. You can go to the store. Anybody can go to the store without a license and buy a barrel. No problem. Go buy a gun barrel. You don't need a license. You don't need anything. Just go buy a gun barrel. Gun barrel, it can be used as a weapon by banging somebody over the head with it. That's about it. You can go buy springs. You can go buy a slide. You can go buy little pieces that, if you assemble it, will not make a firearm without a serialized firearm part. The federal government considers a firearm that part that has a serial number on it. Typically, it is, if you're looking at something like an AR-15, it is the lower receiver. So what this bill would do is it would essentially ban the paperweight. It would ban the one thing that is not a gun and cannot be made into a gun without machining, without using metalworking tools, without turning it into something that it is not, without turning a paperweight into a gun. That's what we're trying to ban. Now, I disagree that we shouldn't. I disagree that this bill should go forward at all. That we should say people can't make their own guns, because people all over this state make their own guns all the time, very responsibly, legally. They're not doing it in order to try to skirt our laws, because our laws say they can do it, and so does federal law. I disagree with banning that. However, at least we understand that. What we don't understand is this: what mechanism, what piece of metal is going to be illegal? Is it only if it's advertised as a lower? What if it's advertised as a paperweight? I went on the internet and I found all kinds of advertisements for AR-15 80% paperweights. That's what they're classified as. That's what they're sold as. That's what they're marketed as. Paperweights. 80%. Why 80%? How about 79%? How about 15%? How about 0%? I went on the internet and found a 0% billet AR-15 lower receiver. What is it? It's a block of aluminum. 0%. Is that what we're trying to ban? A block of aluminum? You need a machine shop. You need specialized skills. You need to be able to turn this bare block of aluminum, a 0% aluminum billet AR-15 lower, into a gun. You can't, like, most people can't do that. Well, most people can't turn a 79% or an 80% or a 50% paperweight into a lower receiver. So what are we trying to ban? We're going to ban every piece of pipe. My dad used to work at a school in the South Bronx, and every couple of days he'd come home with a shoebox full of switchblade knives, zip guns. There's a little zip gun, which is basically just a little piece of pipe with a rubber band and a rock. And all you do is you pull the rubber band back, let go, it hits the bullet, and it fires. How are we going to ban that? We're going to ban pipes, we're going to ban rubber bands, we're going to ban rocks. There has to be some way for the person of average intelligence to understand what we are banning. This bill is completely unintelligible. Let me give you federal law says that once the machining of a firearm reaches a certain point, it doesn't give 80%. The federal law doesn't say anything about 80%. Federal law says that it becomes a firearm when it has the capacity to be turned into a firearm. So if we're talking about AR-15s, once the paperweight is machined to the point where you can insert a trigger assembly and other moving parts into it that are necessary to turn it into a functioning firearm, then it becomes a firearm. And what you can do is, if you make these things, let's say you produce 80% lowers, so you think they're 80%, or you produce 50% lowers, or you produce 0% lowers. You can send those to the federal government, to the Bureau of Alcohol, Tobacco, and Firearms, and you can say, is this a firearm? Is this machine sufficiently to be considered a firearm, or is this a paperweight? And what ATF has is a laboratory, and they also have a testing facility, and they will look at it, they will examine it. They have staff that will analyze it, that is knowledgeable in the area, and they will look at it and they will say, this is machined sufficiently that it is now a gun. And if it's a gun, if it's in Connecticut, and a law like this would pass, well, then it would need a serial number. But if ATF says, no, it's still a paperweight, then it would not make any sense to have a serial number on a paperweight. We don't have that capacity in the state of Connecticut. We don't have such a lab. We don't have people that can do that analysis. We don't have people that can issue those reports and tell you the thing you have is a hunk of steel, is a paperweight, or the thing you have is a firearm. They have that at the federal level. They do that at the federal level. We should allow them to continue to do that at the federal level and not try to get involved in it, because we don't have the expertise. We don't have the facilities, and we don't have the funding to create the facilities or the expertise. If we can't even afford to fund the statewide firearms trafficking task force, there's no way we're going to be able to fund a facility and the resources to tell people if the thing that they have is a gun or a paperweight. Now, in order to really understand how bad this bill is, you need to know a little bit about guns. Now, I know most people don't. They know, which end the bullet comes out and which end makes the noise, where the trigger is, where the stock is. Most people couldn't identify the forearm. Most people couldn't identify an upper or lower receiver. Most people wouldn't know what a frame or a grip is. But we assume that the people who write our laws do. And unfortunately, having gone through this bill, that assumption is incorrect. And I'll give you a couple of examples in a minute. A lower receiver on an AR-15 is essentially the middle part, the part that has the trigger in it. But the lower receiver itself doesn't have any moving parts. None. Not a single moving part in it. You can put moving parts in it. You can put a trigger assembly in it. You can put a magazine release in it. You can put other parts in it that together with a lower receiver become a firearm, become a functioning shooting weapon. But without all those parts, all it is a piece of metal. Now that piece of metal, if you buy one in the store, will have a serial number on it, because it will be considered by the federal government and the state government a firearm. But if you buy one that doesn't have any holes in it, that doesn't have any place to put the trigger, that doesn't have any place to put the magazine or the magazine release. That is a paperweight. Now, sitting on top of the lower receiver is what's called the upper receiver. The upper receiver in an AR-15 typically houses the bolt assembly. It has what's called the breech lock. It has the barrel. The barrel attaches, actually with an AR, the barrel attaches partially to the lower receiver and partially into the upper receiver. And the bullet, the round, goes into the upper receiver through the magazine. So there's a difference between an upper receiver and a lower receiver. There's a difference between a frame. A AR-15 really doesn't have a frame. It has two receivers. Most handguns, however, have a frame. They don't have a lower or an upper receiver. A frame is basically a handle with some holes in it. In the handle goes, on top, goes a slide with rails and a barrel. That's where the breech lock is. All right? So there are very specific things that are identified in a firearm that most people don't understand. They don't have to understand it. But when we're drafting laws that outlaw certain things, we've got an obligation to understand what parts of a firearm are what. And when we put these things into law, we have to put them into law correctly. We have to use the right terminology. Because if we don't, good people are going to get tripped up and they're going to get arrested and their lives are going to be ruined. We have an obligation to our constituents to make sure that when we're trying to ban something, we know what it is we're trying to ban, and it's not just some image and some concept that's on a website. So I've been thinking long and hard about this bill and what to do with it. Anyone who understands the function of firearms just knows how silly it is. I've actually gone over it with some people in the firearms industry, and they literally crack up because we're describing things that don't exist. We're describing things in this bill that make absolutely no sense, that are contradictory and that contradict both state and federal law. And they look at me and they say, what is this trying to do? And I explain what the purpose of the bill is. And they shake their head and they say, you know, somebody with some type of firearms knowledge should have been involved in drafting this bill. Clearly they were not. This bill is so bad that a person of ordinary intelligence would not be able to understand what is being banned and what is not, what is legal and what's not. If they possess something, they will not have any idea if what they possess will turn them into a felon and put them in prison or not. So I was torn. I have to be honest. I was torn as to whether or not I should try to introduce an amendment to fix it, even though it's a policy that I strongly disagree with, and make it less ambiguous and make it something that people of ordinary intelligence could understand, or if I should just leave it alone and let it pass in its current state and allow the courts to look at it and see just how incomprehensible it is. There were a lot of people who encouraged me not to present an amendment and not to try to fix it. They said, you know, just let it pass, it'll never be upheld in court because it doesn't mean what the legislature thinks it means. And that it's so ambiguous that it can't possibly be upheld in court. I considered that. The problem is that anyone that would challenge this would likely first be arrested, have their guns seized, and spend thousands and thousands, if not hundreds of thousands of dollars defending themselves, and have their lives ruined trying to prove that what we passed makes no sense. And unfortunately, the courts will presume that the legislature knows what it's doing, even if it doesn't. The courts will presume that the language written into this bill conveys the legislature's intent, even if it doesn't. And the courts will presume that we anticipated the consequences of this language, even though clearly we did not. So what do? Do I leave it defective and ambiguous and hope the court will overturn it? Hope the police will use their appropriate discretion and be able to interpret what the statute is when they look at any given device? I could do that, but that would leave my constituents at risk. And it would leave this bill with incredible booby traps in it that I frankly just couldn't live with myself if I allowed that to happen. So, a fixed bill, excuse me, fixed bill. I don't like this bill. I don't like the concept. I think it's bad policy, and I think it infringes on the constitutional rights of every person in this state. We cannot fix all problems. We're just people. We can't legislate away concepts on the internet. But I see my primary responsibility as a legislator is to not make things worse. Not to let bills get through here with legal landmines that I can plainly see. And not to pass laws that nobody can understand. Connecticut gun laws are full of these landmines. And I'll give you a couple of examples. A few years ago, we passed what's called an assault weapons ban. Right? A lot of discussion about that over the years. Some discussion about it here. Connecticut General Statutes 53-202A. Right? That lists what assault weapons are, defines assault weapons, has a whole bunch of guns listed right there in the bill. Certain bills are banned by name. Well, if somebody looks at 53A-202, they'll see assault weapons means, and Section B says, any of the following specified semi-automatic center-fire rifles or copies or duplicates thereof with the capacity of any such rifles that were in production prior to or on April 4th, 2013. And it's got a huge list by name: AK-47, AKM, an NHM-91, an Orinco 56, Vector Arms AK-47, an AR-10, Olympics Arms AR-15, Rock River Arms LAR-15, blah, 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 blah. Whole big list. And on that list is the infamous Remington Tactical Rifle Model 7615. Ooh boy, that's a nasty one. It has the word tactical in it. Does anybody know what a Remington 7615 is? It's been on this list of banned semi-automatics for the last 5 years. Well, I know what it is. It's a pump-action rifle. It's not even a semi-automatic. It's been banned as a semi-automatic assault weapon for the last 5 years. It's not even a semi-automatic rifle. It's a pump action. For those who are uninitiated, that means you have to manually load each individual round into it. Each one. So How in the world is that on the list of banned semi-automatic assault weapons? Here's a description of it. A Remington Model 7615 rifle is a manually operated weapon that uses sliding forend to operate its action. Why is it on there? And what do we get? How about somebody who owns one? Somebody who owns a pump-action rifle. Lots of people own them. They're a very popular target rifle and a very popular hunting rifle. But we've got them on the list of nasty, evil assault weapons. Nobody in their right mind who owned one would ever think that that firearm, a pump-action rifle that's used primarily for hunting, would be on the list of assault weapons that is banned. Nobody would think it's even semi-automatic because it's not. Nobody would think it's an assault weapon because other than the fact that it's listed on here, it's not. Nobody that owns one would ever even think that it's on this list or that it's banned in Connecticut. But heaven forbid they are found with one by a police officer who looks at the list and says, yep, on the list, you're a felon now. Why is it there? Why is a pump-action rifle on the banned list of semi-automatic assault weapons? Because whoever made this list didn't know that it was a pump-action rifle. Clearly. They opened up a catalog, looked at a bunch of things that they thought were ugly looking and mean, and they put them on the list. There's no doubt that people who own these guns believe they are doing the right thing and they have not broken any laws. They don't know. They don't know that they are literally felons. And they face, if they're caught, a permanent felony conviction on their record, loss of their Second Amendment rights for life. They may lose their houses, their families, all their money. They may be in jail for a long time. All because we drafted a law that nobody understands. That's what this ghost gun bill is. A law that nobody can understand. I'll give you another example. The Winter Olympics just finished. NBC did a really good job this year. They put on good coverage of the biathlon, where you ski and shoot at the same time. You know, you ski, you do cross-country skiing with a rifle on your back, then you stop, you shoot some targets, you get back on the slopes, you do some more skiing, you stop, you shoot more. I know they had better coverage this year than any other year that I can remember. Hopefully a lot of you saw it. The guns they use are very specialized. They have all sorts of weird bells and whistles on them. They have these crazy adjustable stocks. They have adjustable triggers. They have shoulder straps, precision sights. They have ergonomic grips. They have weights and balances all over them. They're massively expensive, $5,000 to $10,000. They look like assault weapons. They look like things that are mean and evil. But they are specifically designed for Olympic events. Well, the same goes for the firearms they use in the summer games. In the summer games, they use high-precision target pistols. Very expensive, .22 caliber pistols. They can cost up to $5,000 a piece. As far as I know, there's never been a report of a crime ever committed with a high-quality Olympic target pistol. No self-respecting street thug would be caught dead with one. But under Connecticut law, They are assault weapons, banned under our law. If you're an Olympic athlete, the highest level of Olympic competition in this world, you cannot train in Connecticut because your target pistol is banned as an assault weapon. Why? Why? Because it has the magazine well in front of the grip instead of in the grip. I have to ask this question. Who the heck cares where the magazine well is? It's an Olympic target pistol. Yet it is banned as an assault weapon. And it's been banned for the last 5 years, and despite introducing bills to get it off that list, it's still banned. We've not been able to get those bills through, and Olympic athletes can still not train in Connecticut with one of those pistols. But you know what? Nobody with one of those pistols would ever think that their gun, their Olympic pistol, was banned. Now, I have, let me go through my amendment. Mr. Chairman, I have an amendment that I'd like to hand out. If I, should I give that to the clerk?
Yes, the staff will help us if the two, Madam Administrator, Assistant Clerk will assist us.
Just make sure I got one.
Committee will stand at ease for a moment. Okay, Representative Dubitsky, please proceed. I believe the amendment is distributed to the committee.
Thank you, Mr. Chairman. Mr. Chairman, if I may be allowed to summarize my amendment.
I first would entertain a JFS for the, or a motion for this amendment.
Okay, I move that I move this bill to amend.
Sorry, just yep.
To amend the JFS language.
Okay, is there a second? Second. All right, it's moved and seconded. Representative Dubitsky, please describe or explain your motion. Thank you. Your amendment.
Thank you, Mr. Chairman. Mr. Chairman, what this bill does, and I'll go through the exact text in a moment, but what it does is it leaves the part of the, as I described, the underlying bill tries to ban these so-called ghost guns in two ways. One is to say you can't turn something into a gun without a serial number. The other one is trying to define these various types of blocks of metal and plastic. What this bill does is it retains the first and it eliminates the second. So what it does is it says that it would still be illegal under this amendment to turn anything into a firearm, whether it's an 80% receiver, a 50% receiver, a 2% receiver, into a firearm without going through the process that was laid out in the underlying bill to obtain a serial number. But what it gets rid of is the ambiguity as to what thing you can't possess, because it's the possession of the thing that is the ambiguous part, because there's always the question, what thing is banned and what thing is not. So this allows the underlying idea of prohibiting so-called ghost guns to be turned into firearms, but what it doesn't do is it doesn't ban a piece of metal that is under federal law a paperweight and is impossible to define when it turns into a firearm or not. So going through my amendment, the way that I do that is in the first amended portion is on the third page, section 19. I remove the words and any unfinished frame or lower receiver as that term is defined in this section. And I'll explain why. It retains the current definition of firearm, does not change the definition of firearm to include a frame or an unfinished frame or lower receiver. And I'll explain why that is. In paragraph 24 of section 1, frame or lower receiver is defined. In the underlying bill, it's defined as you can see. I don't need to read the whole thing, but it's defined as a piece that holds the hammer, bolt, breech lock, or firing mechanism. Right? That's defined as frame or lower receiver. And where did that language come from? I'd be willing to bet most people have no idea where that language comes from. Well, I do. That language comes from federal law. And federal law, specifically 27 CFR Part 478. It's got the exact same language, but it's got that language for frame or receiver, not lower receiver. So as I described before, there are parts of a gun that are housed in a lower receiver on guns that have them, and parts of a gun that are housed in an upper receiver with guns that have them. I have talked to people in the gun industry, and not a single person could think of a firearm that had a lower receiver that houses a hammer, bolt, or breech lock and the firing mechanism. So if we define a lower receiver as something that contains those things, we've just defined something that doesn't exist, because there aren't any firearms that have those things in a lower receiver. Now, under federal law, it says receiver. Well, yes, those things are in a receiver. They're either in a lower receiver or in the upper receiver, but they're not all in the lower receiver. It doesn't work that way. Somebody just cut and pasted language from federal law into this bill, and they used it improperly. So anybody who knows firearms can look at this and say, oh, those things that are the defining characteristics of a frame or lower receiver, which is a part of a firearm that provides the action or housing for the hammer, bolt, or breech lock and firing mechanism, are not in a lower receiver. So how do you define that as the lower receiver? It makes no sense. A person of ordinary intelligence reading these things would not understand what this bill is trying to do. So my proposed amendment would remove that language entirely and retain the language that says you just can't turn something into a gun without a serial number. Easy. Everybody gets that. Now, moving on in the amendment, there, in Section 2A and several sections in several subsections of Section A, it uses the word assemble. So it says, no individual shall manufacture or assemble a firearm without first getting a serial number. Well, to assemble a firearm means to take a bunch of parts, including one of them, which is considered the firearm under federal law, in the case of an AR-15, the lower receiver, and put those parts together into a functioning weapon. That's what assembly is. You take parts, you put them together. Well, under this bill, the mere assembly of a weapon from parts becomes a violation of the law. So if you have a firearm without a serial number, and there's thousands of them in this state, many of the guns made before 1986 have no serial numbers. Not all of them. There are some that do, but many of them don't. If you took that gun apart to clean it, you have the barrel over here, you have the springs, you have the housing, you have the receiver, you have the stock, you have the trigger assembly. You couldn't put it back together under this bill because that would be assembling a firearm. It's also circular. And when I say circular, I mean that if you can't assemble a firearm with a firearm. And under federal law, the firearm, and under the definition that is proposed here, the firearm would be the receiver with no moving parts. So you can't assemble a lower receiver with a lower receiver. It makes no sense. The language was just cut and pasted. It is not comprehensible for anybody who knows anything about firearms. Now, in Section 2B, now we get to the real doozy. Section 2B of this talks about the manufacture of any firearm with polymer plastic. All right? No individual shall manufacture or assemble any firearm from polymer plastic unless such plastic is embedded with 3.7 ounces of material type 17-4 pH stainless steel. Right? And it's got a serial number. Embedded with a piece 3.7 ounce 17-4 pH stainless steel. What's that for? Why do you have to embed this piece of stainless steel into a plastic lower receiver? Well, obviously because people want to be able to see these things on a metal detector, right? Okay, understood. Now, where did that language come from? Why specifically type 17-4 pH stainless steel? How about a hunk of carbon steel? Why that? Well, I know the answer to that one too. Where does that come from? That comes from federal law. Federal law, 18 U.S.C. Section 922, subsection P. No, it shall be unlawful for any person to manufacture, import, sell, ship, blah, 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 or receive any firearm that after removal of the grip, stocks, and magazines is not detectable by the security exemplar by a walk-through metal detector calibrated and operated to detect the security exemplar. What is a security exemplar? It is a piece of metal made out of 17-4 pH stainless steel that is shaped like a gun. So, essentially, federal law says that if you make a gun with all the parts, with the barrel, the slide, the trigger assembly, the grips, the frame, everything, if you make a gun like that, it has, in its assembled form, it has to be at least as detectable in a metal detector as a piece of metal 3.7 ounces of 17-4 stainless steel that's shaped like a gun. So what they do is they create what's called a security exemplar. They take a piece of metal, a piece of stainless steel, they shape it into a gun, and they send it through a metal detector. And they take a reading as to how high it reads on the magnetometer. And then they take the firearm and they send it through the magnetometer and they check the reading. And they say, this firearm needs to have a reading as high as the exemplar. It doesn't say you take the exemplar and you try to embed it into the gun. That is silly. It doesn't, everybody knows what a Glock is, right? Glock is a handgun with a polymer grip, which call it polymer frame, and it has a steel slide, a steel barrel, a steel internal parts, trigger mechanism. All it's basically a steel gun with a plastic handle. The plastic handle, which we are defining as a firearm, which has the serial number on it, weighs about 4 ounces on a full-size one and about 2 ounces on a compact one. The gun itself, though, has almost 2 pounds of steel on it. The slide, the barrel, the trigger mechanism, 2 pounds of steel in that Glock. But the grip itself is very light, has no moving parts. It's just a little piece of plastic. Under this bill, what they've done is they have taken this federal law that is designed to have a gun-shaped little piece of metal that they run through a metal detector. They're insisting that you take that piece of metal, which weighs 3.7 ounces, and try to embed it into a 2-ounce plastic grip. Where are you going to put it? It doesn't fit. It makes no sense whatsoever, and it completely misinterprets federal law. So anybody who understands federal law and understands that that piece of metal is supposed to be run independently through the metal detector, and they check the magnetometer reading, and then you take the gun separately and put it through and check the magnetometer reading. Anybody who understands that looks at this and says, so what does this mean? Does this mean now that I have to try to take that gun-shaped piece of metal and somehow embed it into the gun? Well, that's what it says. It doesn't make any sense. Whoever wrote this did not understand what they were cutting and pasting into our law. And what that means is that the person of ordinary intelligence is not going to understand it. And that means good people who are trying desperately to follow the law are going to get caught up, are going to get arrested, are going to be felons, all because the people who wrote this bill didn't know what they were talking about, didn't understand firearms, and didn't understand firearm law. So my amendment would instead get rid of that embedded language, and it would replace it with language that follows federal law that says that if you're going to make a gun, that gun in its assembled form needs to be at least as detectable in a metal detector as the security exemplar. Takes the same language, 3.7 ounces of 17.4 stainless steel. If you make one of those into the shape of a gun and run it through a metal detector, any gun you make needs to be at least as detectable as that. People understand that. That's what's been federal law for a long time. That is what people expect to see in a law. So it adds that language with regard to the security exemplar and the testing. What it also does is, and it goes through, it takes out the word assembly, because again, assembly does not mean what it is apparently intended to mean in this bill. And then it retains the exemption for federally licensed manufacturers of firearms. And I believe that's about all it does. So in summary, what this bill does is it eliminates the ambiguous language that was cut and pasted from federal law incorrectly, misinterpreted, and put into this bill that would have the effect of confusing anybody who was trying to comply with it. And it maintains the underlying purpose of requiring that anybody who builds their own firearm must get a serial number from the state police. And it essentially does the exact same thing as was discussed during the public hearing as the intent of this bill, but it does it in a way that will not trip people up and will not get good people inadvertently arrested and put in jail. And I urge adoption.
Thank you. Chairman